Yeah, so we would like to move to another topic in our constitutional law. That is the concept of constitutionalism. It is worth recalling an aspect of interesting quotation attributed to James Madison that, quote, "If men were angels, no government would be necessary," unquote. You know how angels are. God has made them a very perfect being, and they have a smart intelligence. They know in a split second how not to do wrong, and they always hold themselves in check. So angels, they don't need, if you like, a governance, so to speak. But human beings, we are not like that. So in this topic, we seek to understand the concept and historical development of constitutionalism. Globally, that is generally, and in relation to Ghana's constitutional law. We also seek to analyze or explore the practice of constitutionalism in Ghana, both before and after the coming into force of the 1992 Constitution. Thirdly, in this topic, we seek to examine the challenges and manifestations of constitutionalism under military regimes. Of course, we've discussed the legal effect of coup d'etats and revolutions on the pre-existing constitutional order not too long ago. So that should ring a bell. And finally, within the context of all this, we also seek to have some comparative exercise in terms of how constitutionalism applies under a written constitutional regime and how it applies under unwritten constitutional regime. We'll be drawing upon comparative examples from various jurisdictions. So in a nutshell, that is what we seek to achieve in this topic. But maybe before we move on, we will raise rhetorical questions. Rhetorical questions in the sense that I am not going to wait for answer now, but I want you to keep thinking about them, and they should be at the back of your mind as we journey through this topic. Is a constitution written or unwritten the surest way to ensure restraint on government? Already we are told that human beings by our very nature, as somebody will say, that we are just perverted in terms of having the tendency to overstep our space and interfere with others and so on, or lord it over others if we can. So there's need for restraint on government. But the question is it having a written constitution which will ensure that you have a governmental system that imposes restraints on those who wield governmental power so as not to undermine the liberty of the citizenry? Or having unwritten constitution will just do that as well? Again, how can a people make restraint on government effective? How can limitations that we seek to place on those who wield governmental power, how can it be effective so that those who wield governmental power, they don't exercise untrammeled power, unlimited power? As somebody would say that absolute power corrupts, Lord Acton. Or power corrupt absolutely and absolute power corrupt absolutely, so to speak. Another question worth pondering at the very initial stage of this topic is, will the existence of constitutional guarantees and legal restorations be enough to ingrain constitutionalism. In other words, if you have various arrangements on your constitutional tablet, in your constitutional document, or whatever constitutional arrangement that you have, having those arrangements, are they necessarily a guarantee, an assurance that you are going to have constitutionalism, you are going to have limited government, you are going to have restraint on those who wield the necessary governmental authority? Then we may also want to find out, should there be the internationalization of constitutional law principles to ensure constitutionalism? In other words, is constitutionalism as a concept so important that if you want to ensure that it's very well entrenched and working, then it should not just stay in one country or one jurisdiction, that the global community should embrace it and must have some reflection in, even if you like, at the international level. Should it be that far before we can actually realize the benefits of it in our municipal legal system? Again, are the attainment of rights, liberties, and restraints useful to a people in dire financial and economic distress? That is to say that if you have a country, maybe like ours, where a good number of people are struggling with their next meal and all that, do they really care about imposition of restraint on government so that their liberties are safeguarded? Or they are more concerned about how to get employment, how to put food on the table and all that, and they don't really care about whether the government has absolute power and is able to circumscribe or overstep the liberties of the citizen. So how do you draw the balance between economic development and the need for rule of law? So if you want to achieve a fast-paced development, should you sacrifice constitutionalism? People often point to Rwanda, as Rwanda having come out of their genocide, unfortunately, which claims so many lives. They evolved a governmental system in which things are working, and you go to Kigali and so on, everything is in order. But we are also told that there are significant infractions on the rights and liberties of the citizen. Or you go to some other big countries that we know very well, they are doing well, but the citizens don't enjoy the full complement of rights and liberties as they should. Nevertheless, in terms of economic development, reasonably, they are doing well. So, by way of introduction, what is constitutionalism? What is constitutionalism? Well, just at the very beginning, we could say that constitutionalism is the idea of limiting governmental power to prevent arbitrary rule and protect citizens' rights. So the quest to place brakes, place limitations or restraints on governmental power in order to ensure that there is no arbitrariness on the part of those who wield governmental powers. And of course, arbitrariness would mean that they can curtail or suppress the rights and liberties of the citizenry at any time and any day. So constitutionalism, understood in that simple terms, has a purpose of establishing systems to ensure that power is distributed, controlled, and held accountable. So there should be accountability on the part of those who wield governance, authority, or power. Now, when it comes to our country, Ghana, the 1992 Constitution, of course, as we are aware, plays a crucial role in safeguarding constitutionalism as it seeks to embed principles of democracy, rule of law, and human rights. And if you had the slightest of doubt regarding the veracity of this observation that we are making, I will invite you to look at the preamble of the 1992 Constitution. If you look at the preambular statement of our Constitution, which among other things says, quote, "In the name of the Almighty God, we the people of Ghana, in exercise of our natural and inalienable right to establish a framework of government which shall secure for ourselves and posterity the blessings of liberty, equality of opportunity, and prosperity, in a spirit of friendship and peace with all peoples of the world, and in solemn declaration and affirmation of our commitment to freedom, justice, probity, and accountability, the principle that all powers of government spring from the sovereign will of the people, the principle of universal order of suffrage, the rule of law, the protection and preservation of fundamental human rights and freedom, unity and stability for our nation. Do hereby adopt, enact, and give to ourselves this Constitution." So right at the very threshold, at the very doorpost of our constitutional edifice, we have been shown that we aspire to have a governmental framework which safeguard the liberties of the citizen, which ensures accountability on those who exercise authority. And for that matter, a governmental system which places restraint or limitations on wielders of governmental authority. And again, if you look at Article 1 of the Constitution, we'll be told that the powers of government inter alia are to be exercised in the manner and within the limit laid down in this Constitution. So that statement from Article 1, Clause 1, in itself is sufficient endorsement of the concept of constitutionalism within our constitutional project, which we ushered in with the coming into force of the 1992 Constitution on 7 January 1993, so to speak. So let's keep this at the back of our mind as we make progress. The tension is between the atomistic individual, this one person here on my left, and then the colossal or the conglomerate, that entity called government. And of course, government also represent the state authority and all that. Those who know the government needs to be checked so that the rights of the individual will not be sacrificed unduly. So how to navigate the fine balance between safeguarding liberty and at the same time ensuring that the wheels of governance also run smoothly, so as to deliver the goals of governance. That is what constitutionalism essentially says to pursue. So constitutionalism involves placing legal restraint on the powers of the government to prevent arbitrary rule. Arbitrary rule in the sense of you just wake up one day, government says that all those who have a car registered in 2024 should go and park the car at the nearest police station because the government has taken over all those cars, or all those who are having some dollars in their bank account because the Ghana cedi and the dollar exchange rate is getting worse and worse. As part of measures, government has taken over everybody's foreign currency. That is arbitrariness, and that is what constitutionalism seeks to guard against. So therefore, constitutionalism ensures the rule of law and enforces separation of powers and protects fundamental rights of individuals. So all these work together to achieve limited government. Yes, if we have written constitutions such as ours, they serve to codify these restraints. Just I gave you an example. If you look at Article 1, Clause 1 itself, it says that the authority or powers of government are limited, are supposed to be exercised in the manner and the limits within this constitution. So that in itself is evidence of, if you like, codification or trying to put on a constitutional tablet the kind of limitations that we want to place upon those who wield constitutional power or the powers of governance. So at the very outset, and drawing upon Professor Kumado's ideas in his work, A Handbook of Constitutional Law of Ghana and History, it is critical to distinguish between constitutionalism and mere existence of a constitution. In other words, having a constitution ipso facto, or by that very fact, is not assurance that you have constitutionalism. If constitutionalism is understood as having restraint on powers of governance and all that, again, a constitution serves a descriptive or organizational purpose. A descriptive purpose in the sense of, yes, the various things, organs, institutions, everything is described, isn't it? You know, how parliament was a composition, the executive, the judiciary, and so on and so forth. So how, if you like, the state is organized. It's beautiful, but that per se is not what constitutionalism is. Constitutionalism is normative and prescriptive. Constitutionalism is about values. It's about values. You know, the idea, the conviction that there's a need to restrain the wheels of governance so as to safeguard the liberty of the governed or the citizenry. Yes, there is relationship between constitutionalism and constitution, no doubt about that. But the point needs to be made that they are not synonymous. And for that matter, they are also not interchangeable. So we cannot say that constitution is the meaning of constitutionalism or vice versa, as it were. Again, constitutionalism does not automatically equate to democracy, especially if we talk about democracy as government of the people, by the people, and for the people. Yes, having democratic institutions such as maybe political parties, multi-party, multi-party arrangements. Of late, people have been talking about the danger of a duopoly, duopoly, that is having two major political parties in Ghana. Of course, our constitution does not talk about that. Our constitution talk about multi-partyism or multi-party democracy. That you have many political parties. Of course, having free and fair elections, having fixed term of office, they all contribute to a constitutionalized government. On one hand, when juxtaposed and also brought in contact with other important ideas like separation of powers, rule of law, and human rights. So separation of powers, rule of law, and human rights, they will deliver you constitutionalism. But if you just have these democratic matters we talk about just in isolation on their own, they may not be assurance of constitutionalism. That is the point Sir Kumado is trying to make. Fundamentally, then, constitutionalism refers to the governance of a state according to predetermined rules that limit governmental actions. The idea that there should be predetermined rules, not ad hoc rules, not rules based upon knee-jerk reaction or ex post facto rationalization rules, but predetermined rules that limit governmental actions. So these rules are established prior to governmental decisions. The rules are in place before the government will act, before the government will make one decision or measure as it were. And are all designed to restrain the exercise of power and prevent governance by personal whims and caprices or decrees of the governor over the governed. So therefore, the limitations contemplated within the concept of constitutionalism may be institutional limitation, maybe procedural limitation, or maybe substantive limitation. And it's the same idea which are translated into institutional constitutionalism, procedural constitutionalism, and substantive constitutionalism, as it were. So the essence of all this is the need for legal mechanism that effectively enforce this constraint on governmental power. And for such mechanism to function properly, there's a need for independent judiciary. If you are talking about placing restraint, placing limitations on governmental power so as to protect the freedom and liberties of the citizenry, then it follows naturally that there should be unbiased, impartial umpire or referee that will make a determination as to whether those who wield governmental authority, whether they are staying within the limits imposed on their powers or they have overstepped their bounds. And that independent, unbiased umpire or referee is independent judiciary. So the judiciary must be protected from undue influence from the executive, legislature, and other centers of power within constitutional framework. Of course, especially in the context of Africa and the third world, as it were. That way, people are confident that if they have cases, they take them to the courts, they will get justice. I would like you to go to your library and try and get this very good article by Professor Kumado. He delivered this as a public lecture, inter-faculty lectures in Ghana, University of Ghana, Civil Liberties and Development. And also Professor Nyabuazi, this is a very old work, a very important work, Constitutionalism in Emergent States. If you go to your library or you go to the University of Ghana library or the Supreme Court library, you find it over there. As I keep telling you, when it comes to learning, if you want to be a good student, and I want all of you to be good students, become good constitutional lawyers, when we refer you to the reading, you have to go and do the reading. Thank you. So regarding the need for independent judiciary as part of how to achieve constitutionalism, some scholars like Henkin has argued that the method of selecting judges, how judges are selected, how people are recruited to become judges, their tenure, how long are they to stay in office, and the conditions of their service are crucial in ensuring an independent world judiciary capable of safeguarding constitutionalism. So that, I mean, these things I think are largely uncontestable. Now, regarding the necessity and the imperative of independent judiciary in order to have constitutionalism, it is worth recalling Chief Justice Marshall's doctrine in Marbury and Madison, if you remember, Marbury and Madison. Marbury and Madison, the case in which the U.S. Supreme Court, presided over Chief Justice Madison, used a very creative reasoning to infer the existence of the power of judicial review in the U.S. Constitution, despite the fact that it is not expressly or explicitly enshrined on the tablet of that Constitution. And Marshall, and I asked you to read that case, so I want to believe that you are a good student. When your teachers ask you to go and read something, you read it. If you have heeded my advice, blessed are you. Good. So if you look at the original judgment in Marbury and Madison, he will make the point, among other things, that yes, if you have a written constitution, then having the written constitution itself, by itself, has the recognition that there are boundaries which have been delineated or clearly defined for governmental authority. And because there are boundaries and all that, then there's a need for one of the organs of government to make a determination as whether the various organs have stayed within the boundaries or they have overstepped it, so as not to undermine the liberties of the governed. If that is so, the question which arises is that which of the various organs is naturally disposed and better placed to play that role? Certainly the judiciary. And it's on basis of that that he asserted the power of judicial review so that the U.S. Supreme Court is able to make no determination as whether something is in violation of the U.S. Federal Constitution or not, as it were. And of course, as you know, in Ghana, we have no problem with that because we have expressly provided this in Article 2 of our Constitution, Article 125, and all that. So therefore, the idea that you have a written constitution is in itself recognition of having limited powers. Of course, you have scholars like Moreau, Professor Moreau, who really made the point that, well, we don't have to overstretch the distinction between written and unwritten constitution because all of them in their unique ways seek to achieve constitutionalism, as it were. So that was a very introductory invitation to us as far as constitutionalism is concerned. We would like to quickly have a historical exploration regarding how constitutionalism has evolved, because in modern times, it's unquestionable. It's become part and parcel of what we call good governance and all that. So we would like to explore historically how it has evolved, Well, some will make the point that the modern understanding of constitutionalism, probably we can have a historical journey back to England and later on to America, their the independence declaration and all that. But it is important that regardless of the politics of the historical origins of constitutionalism, English law or England and to a large extent America have an important pride of place when it comes to a modern idea of constitutionalism, and then various factors are responsible for this. What are these factors? Okay, so during the evolution of a classical conception of English constitutionalism, there was an experiment of a wide range of political ideas. Remember that England, for a long time is monarchical and is still monarchical. But in the early times, there was what they call the absolutism. Absolutism in the sense that the crown, be the king or the queen, was regarded as having absolute authority and could do everything, except when it came to the time that, of course, Christianity had become part of their society. Apart from God, the king or the queen could do everything, so to speak. So that was the era of absolutism. And of course, there will be various revolts here and there, and including and that those when the absolutism is actually operated up to a certain level, naturally people will resist. People will try to challenge, and that degenerate into anarchy, so to speak. And ultimately, the British settled in favor of a governance structure which sought to divide power between the monarch, that is the king or the queen. Now we have like the king, and then the laws and the commons. So if you look at the Magna Carta and all that, how concessions was actually made, that there are certain things that the monarch recognized as belonging to the people and all that. And so everyone knows his limit, as it were. Then we also have like the commons or the commoners, and they were to serve as a check on the power of the crown, restraining the exercise of such powers. So that is why if you go to Britain, you have what you call the House of Commons and then the House of Lords. The House of Commons were actually supposed to be like the forum in which representative of the commoners, so to speak, will be able to play a role in lawmaking, as it were. And eventually, there will be recognition of an official opposition. So it's no longer just the king inviting people that the king wanted to sit in the legislature to help the king to make laws and all that. But eventually, we'll get people electing their preferred representatives, and based upon who won the majority of seats and all that, you're invited to form the government. And those who got like the relatively fewer seats, you will constitute like the opposition. And that has been the trend even today in Britain. And you saw recently how the Conservative lost so many seats. And for that matter, it was a Labour government which was invited by the crown to form government. Now, as we know, the English courts, since the days of the common law, have been very independent, and they have also played important role in ensuring that the crown was not acting arbitrarily, as it were. So if we look at the later on when you are doing judicial review, the rate of prerogative rates, prerogative orders, certiorari, quo warranto, mandamus, habeas corpus. These are some of the royal rates of prerogative orders that were made use by the court to ensure that there was some kind of a restraint on those who exercise authority, even under the guise of the monarch or the crown. Now, the idea of British constitutionalism also had a snowballing effect ultimately, as it also had some impact on development beyond Britain to other continental Europe. And ultimately, as Britain started the empire expansion, seeking of colonies, then they also went with them the kind of governance system that they had evolved. So eventually, constitutionalism was spreading. And we'll just take some specific historical instantiation. We take the American Declaration of Independence of the 1776, for example. We'll get a very good sense of how, even at that very early stage, there was embrace of this concept of constitutionalism. And this is what the Americans stated in the Declaration of Independence, and I quote, "When in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation." So eventually, you have seen how Americans are trying to say that, yes, all of us are human beings. All of us are entitled to certain decent treatment and dignity, freedoms, and all that. And then they'll continue, part of the declaration. "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among them are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. So that among them are life, that is the important right, life, liberty, and pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive of these ends, it is a right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to effect their safety and happiness." So this is the American Declaration of Independence. If you analyze it, you notice that there is emphasis placed on the freedom, liberties, and also the need to curtail or to contain governmental authority, so as not to arbitrarily undermine the liberties of the governed, so to speak. And of course, the 18th century declaration heralded the struggle towards constitutionalism in the 19th century and so many others. So maybe like in terms of a timeline of development of constitutionalism, we could talk about, the the American War of Independence and then Independence Declaration, the French Revolution, Restoration period, German Union, French Revolution, creation of Dominion, Canada, and then the various revolution in 1848. All these historical events reflected the search for governmental arrangements which safeguard the freedom, the liberty of the citizenry. And for that matter, governmental arrangement which places limitation or restraint so as to check against abuses. Well, we will not belabor the point, but if we're interested how the idea of constitutionalism actually spread to so many other places, one would argue that it was probably a direct consequence of industrialization. Industrialization brought economic empowerment, and all of a sudden, the middle class people had come to realize that, yes, it was not just the aristocrat or the minority elite, but that they were also decent human beings entitled to decent life, respect, and all that. And eventually, it will even trickle down to the lower, if you like, echelon of society, so to speak. So we would like to unpack further this concept of constitutionalism, and then we'll also be looking at some cases and the philosophical background as well. So just contextualizing it, I would like us to look at these images. Thomas Jefferson, who was an American president one time, is quoted to have said, "My reading of history convinces me that most bad government result from too much government." Most bad government result from what? Too much government, meaning that if you give too much power to government, you are likely to get a bad government. Now, if you look at a review of Ghana's 1992 Constitution, I don't know if I've shared the Constitutional Review Commission report with you, but if I haven't, I'll share it with you. One of the concerns which we had, and I happen to have been part of the commission, I was the lead researcher for the whole of Ashanti region. I went around the districts and all that. Now, one of the, this was 2010, one of the concerns that we had, and then you read the report, is that it's like we have too much power vested in the office of president. If you look at our constitution, in terms of appointment and so many things. So that is too much for government. So if we're having problems with our government that we elect every 4 years, it may probably not so much to do with particular party or particular individual, but also even our governmental system itself, how we have structured it, and we need to go back and make the necessary changes. Power tends, then another, of course, power tends to corrupt, and absolute power corrupts absolutely. We've seen that human beings, we have insatiable, crave for power. And once we get power, it gets down our head, and other people suffer. Now, another commentator is also reported to have said that either you limit government or government limits you. And that, I think, is the summary of the whole concept of constitutionalism. Government should be limited. Otherwise, unlimited government, absolute government will mean the citizen will be limited. The citizen will be arbitrarily restricted. So there's no doubt when we are talking about constitutional law, constitutionalism is a very important, it's one of the salient or principal doctrines which we have to pay attention to. So constitutional law ultimately comes to constitutionalism, theoretically what? Speaking. And constitutionalism, as we have discussed variously, seeks to ensure that powers are well defined and holders of powers are limited by law. Basically, that's what it is. Now, question may arise as whether a particular country is adhering to constitutionalism or not. Now, and the view is held that governance activities, as whether reflecting constitutionalism or not, should be seen as a spectrum, right? As a spectrum, as it were, or a sliding scale. So on the one stream end, we could have totally autocratic regime, which has no limitation whatsoever. And then at the far extreme, we can also have extremely restrained regime, extremely limited government. So constitutionalism is an idea, is a value, or an ideal that every state tries to achieve. They're aspiring to have that. They're aspiring to have a governmental system in which governmental authority is really limited in the proper sense of the word, as it were. We'd like to look at some philosophical influences or some philosophical background of the concept of constitutionalism. And it is important to note that various thinkers have contributed to the theoretical foundation of constitutionalism by exploring things like the nature of authority. In other words, why is the state powerful? Why do those who occupy various positions of governance be able to demand obedience from us? Individual rights and the role of government in ensuring justice and security within society. Now, these philosophical ideas continue to shape modern and political legal thought as far as constitutionalism is concerned. So we will quickly look at some of them. But we have already quoted the Lord Acton, the British historian, who said that power tends to corrupt, and absolute power corrupts absolutely. Meaning that if you have any governance arrangement in which you have just given powers anyhow, without putting in place checks and balances, putting in place measures or mechanisms to ensure that no one actually enjoys absolute power on anything, then you are likely to see some negative outcome. Now, in terms of the philosophical background of constitutionalism, we go to the social contractarians, the scholars, who attempted to examine the power of the state or the authority of the state vis-a-vis the governed, vis-a-vis the citizenry. or the justification or the basis for the citizen to feel obliged to obey the state or the state institution. So the various ideas which they propounded are what we call the social contract theory. So one of them, Thomas Hobbes, in his famous work, The Leviathan, which he published in 1651, the 17th century, posited that human beings in their natural state, that is before we came to have like the modern state that we have, lived in a condition of constant war and chaos due to selfish interests. And for that matter, you say that life was really nasty. We are miserable, brutish, and short. Because we are naturally selfish, we like to have our way. And we trying to have our way, we come back to might is right. If I can overpower you, then I overpower you and have whatever you have, which I need. So meaning that no one had peace except those who are extremely strong. So to escape this misery, individuals entered into social contracts and surrendered their absolute freedoms to a sovereign authority, like called the state, the monarch, or the government, in exchange for security and order. So in a sense, we could say that that social contract idea laid the groundwork for modern constitutionalism as it advocated for the establishment of government based on mutual agreement. So where the state has authority, as long as it provides protection and ensures common good. So as long as the state is able to provide your safety and ensure the common good, then your obligation to obey the states. So that is what the Thomas Hobbes is suggesting. And within that, we also see some idea of constitutionalism as far back as that time. After all, constitutionalism, we said, putting restraints on governmental authorities so as to safeguard the rights or liberties of the citizenry. And the same thing that social contract theory, as seen through the eyes or perspective of Thomas Hobbes, also seeks to achieve. Again, John Locke also talk about like the civil society and government as part of social contract theory, and he believed in the fundamental reason and tolerance of human nature, and argued that individuals possess inalienable rights to life, liberty, and property. And Locke holds the view that a social contract was not merely about security, but also about protecting these natural rights. So Locke, for example, say that if you look at human beings in a state of nature, all of us, God has given us strength, hands and legs. Natural things are there, the forests, the minerals, so many things. So if a person is able to apply his strength, his natural powers to acquire something from nature, either through cultivation or through some other things or whatever, then be it. And you acquire property in that because you have added your sweat to what is in nature, and you are entitled to have it protected so that it's not taken away from you by any other person. So that is Locke's idea, as it were. Then we also have Jean-Jacques Rousseau. Rousseau, another social contrarian, also proposed that in a state of nature, human beings were noble and live freely and harmoniously. However, development of private property and social inequality led to corruption and conflict. And for that matter, there was a need for legitimate political authority to arise from a collective agreement or general will of the people, where individuals give up their individual rights for the common good. So Rousseau is talking about sovereignty. So Rousseau says that, yes, each of us, we have our own individual will, but then we surrender, if you like, our will, so to speak, to the states or to the government. And for that matter, we together are stronger than what? Than the individual. And for that matter, the individual, we must yield to the authority of the sovereign state, as it were. And those were the ideas which influenced various revolutions, including like the French Revolution. Yeah, so in modern times, constitutionalism rests on two main pillars from what we've said so far. First, the existence of certain limitations imposed on the state, particularly in its relation with citizens, based on clearly defined core values, like we saw when we read the preamble to our Constitution. And secondly, the existence of a clearly defined mechanism for ensuring that the limitations on government are legally enforceable. So you must have that mechanism for giving effect to the limitations imposed on government. So we would like to look at some scholastic perspectives or some general ideas which have been contributed by some scholars from their writings on constitutionalism. So if you look at the Smiths in his work, for example, writing on constitutionalism, he makes this point, which is quoted in our slides. Quote, the idea of constitutionalism involves a proposition that the exercise of political power shall be bounded by rules prescribing the procedure according to which legislative and executive acts are to be performed and delimiting their permissible content. And then they continue. Constitutionalism becomes a living reality to the extent that these rules curb the arbitrariness of discretion and are in fact observed by the wielders of political power, and the extent that within forbidden zones upon which authority may not trespass, there is significant room for enjoyment of individual liberty, unquote. I mean, essentially, the Smith is talking about the need to control discretionary power, the need to guard against arbitrariness. So, the same way of saying what we have said already, that constitutionalism about having predetermined what? Rules. Predetermined rules. Again, Carl Frederick will make the point, quote, that constitutionalism embodies the simple proposition that the government is a set of activities organized by and operated on behalf of the people, but subject to a series of restraints which attempt to ensure that The power which is needed for such government is not abused by those who are called upon to so govern. Yeah, so that is a Carl Frederick point, and I think essentially is reiterating what we'll be discussing already, and he will make the point further that government must be carried out according to predetermined rules, which at the same time restrain governmental activity. So have rules first before power is exercised, so to speak. So Frederick, maybe like if you come to our constitution, yes, we have the executive. They have the executive has the authority, to govern and all that, but it doesn't govern in vacuum. It must govern according to law. And Parliament will have to make the laws. Executive will have to initiate the laws, and Parliament will take it through these processes and all that. And again, even when it comes to discretionary power, if you look at the Constitution, where a discretionary power has been conferred on anyone, it's also even controlled. You cannot just do it anyhow. So if you have like a discretionary power, you'll be told that you are supposed to come out with the predetermined regulation which will govern it. So you look at Article 296, Article 296 of the Constitution, for example, where in this Constitution or in any other law, discretionary power is vested in any person or authority. A, that discretionary power shall be deemed to imply a duty to be fair and candid. So here, you see that even with discretionary power, you're being told that there's limitation. What is the limitation here? The limitation is that you should be fair and candid in its exercise. Not only that, that the exercise discretionary power shall not be arbitrarily, capricious, or biased, either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. So due process of law means that you must have predetermined rules. You must have guidelines in place, which will let everybody know how you exercise their discretionary power. And see, where the personal authority is not a judge or other judicial officer, there shall be published by a constitutional instrument or statutory instrument regulations that are not inconsistent with the provision of this Constitution or that other law to govern the exercise of discretionary power. So all those who have discretionary powers, apart from those having judicial power, they are supposed to come up with predetermined rules. For those with judicial power, they're already the rules of court, which govern various, and that is why they are excluded. So Carl Frederick maintains that constitutionalism should be understood as an institutionally based interactive system for deliberating the meaning and legal application of the norms of a political community. So that is his take on constitutionalism. And for him, the idea of restraint developed from medieval notions of natural law, superior to any human law, and the Christian doctrine of personality. Now, later, when you are learning legal philosophy, you come across natural law and legal positivism. The natural law is that school of philosophy which holds the view that there are certain higher principles of morality which are superior to positive or man-made law. And human law must approximate to those higher principles of morality. Otherwise, it will not be considered as just law. And if it's not a just law, then it may not even be law at all, so to speak. Yes, we've already mentioned Professor Kumado, my teacher, and a very respected constitutional law scholar in our country. And if we look at his work and his various articles, we extract the ideas that, including the following, that constitutionalism may roughly be defined as an act of providing a system of effective restraints in the exercise of governmental power. That is what Sekumado says. And he has that it's not the same as democracy, as we've discussed already at the beginning. But the 4th point he missed, which I want to emphasize, is that there must exist in the ethos of that particular society belief in the idea that the power of government ought to be restrained. So, and that is why the point will be made that it's not enough just to have the constitutional tablet, just to have like a document called Constitution and say that because you have that document, constitutionalism has been achieved. No, there must be that sense of, that sense of the value, the conviction in the populace that it is necessary to put restrictions on governmental power. That is very important. Well, we have another scholar who says something which maybe some of you may not agree. I'm talking about Walter Hamilton. Walter Hamilton. What does Walter Hamilton says as far as constitutionalism is concerned? He makes the point, quote, constitutionalism is a name given to the trust which men repose in the power of words and gross punishment to keep a government in order. Of course, on the face of it, if you look at how he has put it, it may sound even like a bit demeaning or insulting. But what do you think? Based upon what that you have said, do you agree with Hamilton that constitutionalism is just a name given to the trust we human beings have put in the power of words and gross punishment to keep a government in order? So the punishment here refers to the constitution, the constitutional tablet. So it's the trust we have in our constitutional tablet, our constitutional document, to keep government in order or in check. Is that all that constitutionalism is about? Anybody can put up your hand, and then I will release you to speak. Okay. Emmanuel Tego. Yes, Emmanuel.
Hello. So far, I think from all that you have said from action, looking at some of the philosophies, the theory that has been. I will agree with Walter Hamilton. I think that the way they could
can you be a bit close to your mic or to your computer so that we can hear you well?
So what I'm saying is that I will agree with Walter.
Agree with Hamilton.
From all that we have said, yes, I think summing up all the views that cover that seems to know that.
All right. All right, thank you. Another scholar, Jeremy Waldron, in his work, Constitutionalism, a Skeptical View, will render himself as follows, quote, constitutionalism is in many ways quite uneasy with or hostile to the idea of popular government and quite willing to neglect or sideline important tasks such as democratic empowerment. Constitutionalism is just a pompous word for various aspects of constitutional law or study of constitutions. So that is another extreme view, trying to say that constitutionalism, the way it is exalted, the way it's held in high esteem, has a rare risk of undermining the need for democratic empowerment. So we're trying to say that democratic empowerment is different and more important than constitutionalism. I'd like you to think about that, and then you take a stand at some point. Yeah, so Kumado will further make the point that, quote, a preliminary issue, which is a constant source of confusion in discussions about this concept, that is constitutionalism, is its relationship with democracy. It is often said, and to some extent accurately, that there's probably no other word in the language of politics about whose meaning so much uncertainty exists as the term democracy, unquote. Of course, those of you who are students of government or political science or history, you will very much agree with my teacher, Kumado, that yes, the word democracy is not amenable to a straightforward definition, as you international and various meanings exist out there. And interestingly, if you look at the international community, you take maybe China, for example. China will increasingly tell the United States that United States should not complain that China is not practicing democracy. And now they will say that they are practicing democracy, but the democracy they are practicing is different from that being practiced in other parts of the world, including the United States of America. Then you also go to North Korea. North Korea, they even have a democratic as part of their name, Democratic People's Republic of Korea, DPRK. But you ask yourself, is North Korea really democratic? Is North Korea practicing democracy? Well, maybe that is something for us to ponder. So, what is democracy at all? Well, a good number of scholars hold the view that a government can be called democratic, one, if it is popularly based, rests on the consent of the governed, which consent is given in universally free election, and which provides a mechanism for the governed to change the governors in the event of dissatisfaction with their performance. So if you have this possibility, then by and large, we could say that there is a democratic government in place. But then we also know that the mere fact that a government is popularly elected does not necessarily make it a constitutional one. We can have people who have made a coup d'etat, and they will tell the population or the citizen that they're going to have election. Only the coup leader is a candidate. So everybody should vote, and they go out of fear. If all voted, endorsing him as a leader. Yes, that's a popularly elected government, but is that constitutional? Is that what democracy is really about? Well, we've already made the point again that a constitutional government and democracy do not mean the same thing as it were. You can have democratic government, which is not necessarily constitutional. But of course, also the reverse is also the case. You can also have constitutional government, which is not democratic one, so to speak, depending upon what you are dealing with. Except that in modern times, you are more likely than not, all constitutional governments are likely to be democratic ones, so to speak. It is also important to note that a country can have a constitution, and yet constitutionalism will be lacking. So mind you, having a constitution is not an end in itself. It's not an end. It's not a destination. It's not a target. And that is why you can have a constitution and yet you will not have arrived at the destination of what? Constitutionalism. And we can give so many examples if we wanted. So bringing everything together, we would like to say that defining constitutionalism is not a very easy one. Nevertheless, we can get the sense from the various ideas which scholars have propounded there and say that constitutionalism is akin or analogous to limited government. It's analogous to limited government. So let's keep that in mind. So therefore, we could say that, and we've quoted this already, that constitutionalism embodies a simple position that the government is a set of activities. We've quoted that when we're looking at the various scholarly perspective on it. So what then is at the heart of constitutionalism? The core of constitutionalism, the existence of restraint and limitation on governmental power. And the individual in a society is the ultimate beneficiary. Because when we have sufficient restraint on governmental power, the individual liberty is safeguarded. So therefore, constitutionalism is about controlling, limiting, and restraining the power of the state. So I will invite you to look at the case, the Supreme Court decision in Asari against Attorney General, 2012, on constitutionalism and its effects on constitutional arrangement, and the response of the court to that argument. So I invite you to look at Professor Asari's argument as well as Attorney General. But what we need to bear in mind in seeking to understand and consolidate our appreciation of constitutionalism is that, first, it is by no means a static principle. It is not a principle which is frozen. It is not an event. It's a growing process. So it is quite fluid. It's quite dynamic. So the core ideas or the core elements identified can change as better ways are devised to limit government and protect our citizens. So now that we have like the digitization, we have like the digital world, we have a e-government and all that. That technological development also presents a unique opportunity for taking some of these traditional doctrines or concepts to another pedestal, as it were. You have the Freedom of Information Act. The fact that government, if government decides not to be transparent, you can force government to make disclosures by invoking the Freedom of Information Act, as it were, and deploying it appropriately. Second, the presence and institutionalization of core elements do not necessarily guarantee constitutionalism. So the things that we talk about, even having separation of powers, rule of laws, human rights, the elections and all that, they are important elements of constitutionalism, but having them on your constitutional tablet are not enough. They must enter the mind and heart of the people, the consciousness of the people that, yes, there is the need to ensure that at every point in time, we don't give absolute power to any government, anybody in charge of governance, as it were. So ultimately or cumulatively, the effect of the core elements is to enhance the chances of constitutionalism. So those core elements rather creates a good opportunity for constitutionalism to manifest. So the essential elements of constitutionalism, as we're talking about, separation of powers. The fact that governance, authority, or power should not be vested in a single individual or single entity or institution, because power corrupts and absolute power corrupts absolutely. If you vest all governmental authority in just one person or one institution, you can imagine the abuses which will be encountered. And that is why, even in Ghana, if we take our constitution, okay, I invite you to go to Article 58, Clause 1. Article 58, Clause 1, who says that, and I quote, "The executive authority of Ghana shall vest in the president and shall be exercised in accordance with the provisions of this constitution." I look at it, and then it continues. "The executive authority of Ghana shall extend to execution and maintenance of this constitution and all laws made under or continuing enforced by this constitution." So it's only the executive authority which has been vested in the president. Then you go to Article 93 of the Constitution of Ghana. Article 93 says, and I quote, 93 Clause 1, let's look at 93 Clause 2, which is relevant to us. "Subject to provisions of this Constitution, the legislative power of Ghana shall be vested in Parliament and shall be exercised in accordance with this Constitution." So, the legislative power of Ghana is vested in what? In Parliament. Whereas the executive authority is vested in the president. So here you see the separation of powers being encountered already. And again, if you go to Article 125, Article 125, Clause 3, we are told that the judicial power of Ghana shall be vested in the judiciary. Accordingly, neither the president nor parliament, nor any organ or agency of parliament or president shall have or be given final judicial power. So, Article 58, Article 93, Article 125 are giving us clear or concrete illustration of, if you like, separation of powers at the very surface, that it is necessary not to locate all governmental authority in just one entity or one institution. Another essential element of constitutionalism is rule of law. The rule of law, due process. Government must be according to predetermined rules. It should not be arbitrary. Equality before the law. And judicial review. The need for independent judiciary to ensure that those who hold governmental authority, their actions and inactions are measured against the Constitution as a benchmark. So we would like to have a brief appraisal of constitutionalism in Ghana. We'll look at the post-independence era. We'll look at constitutionalism under military rule, and then constitutionalism in times of democracy. So post-independence era, I would invite you to read in full and brief the following cases. Ladan against Attorney General number 2. Balogun against Edusei. Ray Akoto and Savina. As for that, I'm sure you are all masters of that case because you were told to read it in the very first class, and I also told you to read it, and I'm sure you've read it many times. Then Owari against Oforiata and others. Of course, as for most of the cases in constitutional law are also reflecting constitutionalism. So most of the cases that we read also reflect the 31st December case, to force the Attorney General and all that. We'll come across them as we look at the beyond the military regimes again. But now we're looking at the early independence era. So if you look at the 1957 era, you want to find out to what extent did the governance arrangement that we have reflect constitutionalism. Well, we would like to explore a few restrictions that were imposed on powers of government or the state. So if you look at Section 7 of the Independence Constitution, for example, provides that the Assembly, that the National Assembly, can pass a vote of no confidence in the government, which will lead to the fall of that government, meaning that, yes, the Prime Minister and his team of ministers who form the government and his ruling party will be jettisoned from power if Parliament was able to pass a vote of what? No confidence. Again, if we look at Section 35, Section 5 of that Constitution, it gave the Supreme Court the power to question validity of laws passed by Parliament. So this was the Independence Constitution, not the Republican Constitution of 1960. So keep that in mind. Then there was also creation of regional assemblies. So we had the regional assembly which were created. And there was a requirement that bills relating to alteration of the regional assemblies will have to be approved by a majority in that region. So these are all, if you like, a restriction on central government and then the National Assembly so that they could not just scrap the regional assemblies. Then there's also restriction on compulsory acquisition of private property and the requirement, the associated requirement for payment or compensation. With the Supreme Court being given jurisdiction to determine the rights of the property owner. So, you know what we call the doctrine of eminent domain. The doctrine of eminent domain, or the power of compulsory acquisition, by which the state can compulsorily acquire a private property when same is considered to be for the national interest or the public purpose, then the law requires that prompt and adequate compensation should be paid. So, yes, the state had a power of eminent domain, the power of compulsory acquisition, but that could not be exercised anyhow, capriciously and arbitrarily. So there was some kind of a restriction mechanism on that power. Again, when it comes to bill affecting chiefs, if Parliament wanted to pass a law which will affect the chieftaincy, reference had to be made to the House of Chiefs concerned, the relevant House of Chiefs. And if you look at the case of a Wari against Oforata, the court underscored that point. And of course, if you look at the current constitution, the 1992 constitution, you get a similar provision carried over, that where your Parliament is going to make any law which affect the chieftaincy and all that, then they will have to make reference to the National House of Chiefs and so on before they can continue with the process. Again, the power to appoint, promote, and dismiss public officers vested in the government on advice of the Parliamentary Select Committee. Now, judges could only be removed by a vote of 2/3 majority of the National Assembly. So this was the state of affairs as far as the 1957 or the independence constitutional establishment was concerned. And for that matter, in the case of Ladan against Attorney General number 2, the plaintiff, Mr. Ladan, pursuant to deportation order, which had been made under the Deportation Act of 1957, was to be deported from Ghana, that is, to be sent away from Ghana back to his country. And Mr. Ladan disagreed. So he brought an action seeking a declaration to the effect that a deportation act could not be applied to him. Why? In Mr. Ladan's view, he was not just a foreigner living in Ghana, he was actually a Ghanaian by birth. So he could not be a subject matter of deportation. Now, while the matter was pending in court, that is why Mr. Ladan was fighting a deportation order in court, Parliament at the time quickly enacted a new legislation, and this was the name of the legislation: Deportation into bracket Othman Laden and Amadou Baba Act 1957. So as the name of the legislation tells you, this legislation was actually passed for certain individuals and not for, if you like, the whole country. Now, under this law, the Minister of Interior could order deportation of the 2 named individuals from Ghana. And again, if you look at section 4, subsection 2 of this new law, it sought to terminate any proceedings in any court instituted for the purpose of challenging validity of any deportation order made against persons affected by this order. So you see what is happening, and how do you feel having regard to all that you have learned about constitutionalism so far? Here is a case. The government has made a deportation order against individuals, and these individuals have gone to court in Ghana saying that a citizen cannot be deported from his own country. So that order should be struck down. And why that case is pending, the government at the time, because the government has majority in Parliament, is able to move very fast, get the National Assembly or Parliament at the time to pass a new legislation and say that the people who were fighting this thing, there's a law, and that law says that they should leave Ghana, and that no court can actually challenge deportation order being made against them. Just imagine that. So that was what was happening. So this was the what do you call the provision. how it actually wrote that on any order of deportation being made hereunder, I'm quoting section 4.2 of the new legislation. On any order of deportation being made hereunder, any deportation order made under Deportation Act 1957 in respect of the same deportee shall be automatically revoked, and if the deportee is in custody under provision of Deportation Act 1957, he may, notwithstanding any proceedings in any court, whether pending or determined, be retained in custody for purposes of this act without being released, and such custody shall be deemed to be legal custody, and any proceedings in any court instituted for the purpose of impugning validity of Alhaji Alufa Othman Laden Lalame Deportation Order 1953 or Alhaji Ahmadu Baba Deportation Order 1957 shall be automatically determined, unquote. Now, remember we said that part of the idea of constitutionalism is that you should have predetermined rules. There should be law before the government will act. The court should be independent and all that. Now, here is the case. When the deportation order was made, it's being challenged in court. The government goes back and change the law and render the case before the court useless, meaning that that case cannot actually continue because the law which they are fighting, under which they are fighting in the court, that law has actually been repealed or amended, and a new law has been made trying to justify the action of the minister deporting them. So the question before the court was whether or not the new Deportation Act targeting the Mr. Laden or traverse the Constitution. In other words, was it in excess of powers conferred by the Constitution? So the court, more or less, was being invited to do judicial review, as it were. Now, Section 31, subsection 1 of the legislation provided that, quote, subject to provisions of this order, it shall be lawful for Parliament to make laws for the peace, order, and good government of Ghana. So, the judge who was adjudicating the matter made the following observation on basis of the provision that I have quoted. Quote, I have considered all the other authorities cited to me, and they illustrate the same point that, quote, the words peace, order, and good government, with no reservation attached, no restriction as to specific subjects, without qualification, give to any country the same plenary powers as are possessed by the Imperial Parliament in England. It was considered that this act of deportation, and that was a momentary indulgence in fantasy, if passed by the imperial government, would be a matter for Parliament only, and the English court would be powerless to interfere. If I so hold the words, peace, order, and good government, unqualified in any way, are plenary powers possessed by Parliament, and no less than the powers possessed by the Imperial Parliament, and it follows, just as it would in England, that the court here has no power to inquire into such an act. I consider, therefore, that any law which comes within the ambit of the Ghana Constitution Order in Council, the Ghana Constitution Order in Council is the constitution which actually was the independent constitution. So that is how, because we didn't have Republicans, that is how it was made. Section 31, and which does not contravene any other provision in the Constitution, can only be challenged in the court of law if it violates or purports to violate subsection 2 or 3 of the section. On that view, the act deporting these two persons, not being contravention of any express limitation in the Ghana Constitution Order in Council 1957, it's a matter for Parliament. It is the same position in the case of South Africa, where the Constitution provides that Parliament shall have full powers to make laws for the peace, order, and good government of the Union. It has been held in the case of Ndwana and Hofomaya. Parliament's will, therefore, as expressed in an act of Parliament, cannot now in this country, as it cannot in England, be questioned by a court of law, whose function it is to enforce that will, not to question it. So as you can see, in the case of Ladan against Attorney General number 2, the court was feeling powerless in trying to challenge Parliament. Because in his view, so long as Parliament has the power to protect the safety and peace of the country, if Parliament had made a law which said that somebody should be deported, then the court could not actually challenge it. But of course, that is a very low moment in constitutionalism. Thank God that Ghana did not remain still. We've moved on. Again, in the case of Balogun against Edusei, 4 persons were arrested pursuant to a deportation order, just like the Ladan's one. 2 days later, their lawyer applied to the court for a writ of habeas corpus on the ground that they were Ghanaian citizens and as such would not be subject matter of a deportation order. Notice was directed to be served on the Minister of Interior, as well as the acting commissioner of police, or the current version of the IGP. The notice was, however, served the following day, although the 4 persons had a day earlier be flown out of the country to Nigeria. So the court found the minister and commissioner to be in contempt of court. But the court stayed execution of their committer to prison, hoping they will be advised to apologize, to purge themselves of the contempt, so to speak. However, on the morning of the adjourned date, Parliament passed a new law known as Deportation Indemnity Act, number 47 of 1958. So the effect of this law is actually to exonerate the 2 persons from all penalties of contempt. So just imagine the abuse of the constitutional power of lawmaking. Just look at that. Yes, Parliament has the power to make law, but look at how it is being abused. When Parliament has made the law and an action has been taken pursuant to that law, and someone is being made to face the musical accountability before the courts, just before the court can actually exact the requisite punishment to take the necessary sanctions, then Parliament passes another law to actually render useless the work of Parliament, as it were. So when later on we come to learn the current constitutional arrangement, you notice that Parliament is forbidden from legislating in a way which will interfere, let's say, that pending matters before the court or reversing like a judicial decision, as it were. So if you look at the same judge who decided the Ladan case also decided the Balong. So Justice Smith, an English judge, and this is what he had to say in the Balongo against Edusei. Quote, so the Edusei, don't forget, we are referring to Krobodusei. Krobodusei, he was the person doing all these deportations. So the notice was, however, the judge speaking. By the passing of this act, I take it that the court's finding that the respondents are in contempt is not challenged by Parliament, but that the intention is to neutralize any consequential order that I might make. It is plain that Parliament prefers that the respondent should not apologize, and it has passed this act in order to nullify any order which I might make in the absence of the apology. The cause of justice exists to fulfill, not to destroy the law. And it will not make sense for me to record an order which is incapable of being carried out. As to the deportations, while the application for habeas corpus was still sub judice, I cannot overemphasize the undesirability of interference by the executive with the functions of the court. Persistent indulgence in such a practice could not have any other than the most serious ill effect on the well-being of the country. Decisions of a court are as binding upon the executive as the laws which Parliament passes are binding upon the ordinary citizen. And it is the court that enforces upon the people obedience to these laws, thereby aiding Parliament in the ordering of the country. In the results, the finding of contempt stands, but I make no further order. So here, you see that the judge was standing his ground regarding the outcome of his adjudication, that yes, I have judicially determined that this person has, or these persons have actually disrespected authority of the court through the contempt of court. But if you have rushed to pass a new legislation which has absolved them from any wrongdoing so that they cannot be punished, then I'm not going to punish them, but you cannot take it away from me that I judicially determined that they are in contempt of court. So see how a judge who has sworn an oath to uphold the law and advance justice was actually suffering under a very rough executive that was abusing their power to rule. Now let's look at 1960 when we had our Republican Constitution, the first Republican Constitution. Now, just to remind you, in case you've forgotten the history of Ghana, that we had independence on 6 March 1957, all right. Ghana was still ruled by the Queen of England, the monarch of England. The monarch of England was our head of state. So we had what we called our prime minister. But we didn't have Republican status. So in 1960, we decided to break completely with the metropolitan colonial power, Britain, and we got our own constitution. And the 1960 constitution, among other things, will say that Parliament has the power to surrender sovereignty of Ghana in furtherance of African unity. That if the president was leading Ghana to take a step which would advance Africa unity, like the OAU and so on, Parliament could pass a law surrounding Ghana's sovereignty. So that was it. And again, in the exercise of executive power of the president shall act according to his own discretion and shall not be required to follow advice. So if the president exercises executive power, he exercises untrammeled discretion. Now, if we look at the Constitution of 1960, Article 12 thereof required the president to subscribe to a presidential oath. And Article 13 requires him to make a solemn declaration. And the solemn declaration, those of you who read the case of Ray Akoto and 7 others, you have come across that. And I think there's a certain, as in public lecture, a lot of public lectures are delivered around Ray Akoto. And last week they also did one. So we look for them and then we share them with you and then read them as part of the general materials. Now, the president under the 19th state constitution also had the power to dissolve the National Assembly, that is parliament. Then, if you wanted to remove the auditor general, you needed to get a 2/3 majority. The chief justice was appointed from one of the judges. But the appointment of a chief justice could be revoked by the president at any time. And appointment and promotion of public officers was only vested in the president. I'm just giving you a highlight of the 19th state constitution. And in 1964, there was an amendment of the 19th state constitution, which established a national party to be the vanguard of the people. And that national party was supposed to be the CPP, Conventional People's Party. So the constitution was actually amended to say that the only party which we can have in Ghana is the CPP. Again, under the 19th state constitution, for reasons which appear, as a part of the amendment of 1964, for reasons which appear sufficient to the president, he may remove a judge. So the president could just remove a judge if he would just give any reasons. The first president was also given special powers. And the president can give directive through legislative instruments, and the president can use legislative instruments to change or alter any existing legislation. So this was generally how the 1960 Constitution, or the first Republican Constitution, looked like. And it was against this backdrop that the case of Ray Akoto and 7 others was actually decided. And as you recall from that case, the appellants were let's see, that's a second. I think we cannot finish. Let's see. We cannot finish today. So I will pause here and then continue at our next class.